All right. So my name is Chris Berry, certified outlaw attorney and certified financial planner with the Castle Wealth Group. And we do these weekly wisdom webinars. Try to do them every week. Sometimes things come up or I'm traveling, so we can't do it every week necessarily, but we try to do it as often as we can. And all I do is log on and answer any legal, financial, or tax questions that people have. And I like to always start with positive focus, just something positive that's happened over the last week or so. Probably most exciting is my daughter's starting soccer tonight. So we have our first practice and I coach her in soccer. So that's always fun. So soccer season is starting again. With that, if you do have a legal, financial, tax planning question, feel free to put it in the question and answer section. But with that, I do have a couple of questions that came in. So let me share my screen and we'll get started. So the first question here. How can I ensure that a disabled or special needs family member is cared for after I'm gone? Um, Really, there's two components to this. So the two components, two things to think about it is one, like actual care. Like, what is the care plan? Is someone else going to step in to serve as that guardian if you have a guardianship or conservatorship? Are they living with you now? Are they living in a group home? So I would say this is the most important thing. Um, and what you would want to do is make sure, even in a will, just like my kids are 11 and 14, I have guardianship language in my will. So God forbid my wife and I pass away, who's going to take care of my kids? You can have that in your will. And then also what we recommend is like having a care plan, which can be just a written document of this is kind of what this person needs or what this person likes or what this person wants. So having a personal care plan that's written down and so that's the most important thing. And then the second, from a legal perspective, is going to be kind of the money aspect of it. Like, how are we going to provide for them financially? And this is where you would for sure want to have a trust in place. There's different types of trust. You can have trust that says the assets go outright to the individual. You can have trust that say it goes to the individual, but it's protected from divorces, creditors, bankruptcies. You can have discretionary trusts where someone else manages it. Like, for example, God forbid I get hit by a bus or my wife and we have someone else managing the money for the kids until they reach a certain age. So they have discretion to pay for school and health and education, maintenance support, things like that. And then you can, of course, have what we call supplemental needs or special needs trusts, where someone else would have to be the manager, they'd have to be the trustee, but they would be managing the money for the benefit of the beneficiary. And they'd be doing it in such a way that whatever you leave to that person doesn't disqualify them from any governmental benefits. So I sat with a woman last week and she had three kids and one of her kids had supplemental needs. So when she passes away, we have the trust set up. So it goes three ways, one share for each one of the kids. The two other kids, they manage their share and it's protected from divorces, creditors, stays in the bloodline. But would have one of the other kids manage the child that does have some supplemental needs. So he would maintain his governmental benefits, but there's a pot of resources available to improve his quality of life to make sure he gets the best care possible. And then the other thing, especially if it's a younger child, think about life insurance, like maybe more life insurance, just to make sure that there is enough funds to provide. So, uh, yeah. So how can I ensure that disabled special needs family member is cared for after I'm gone? Yeah. First thing, again, have kind of a care plan in place and who's going to provide that care, whether it's a family member, whether it's a group home, maybe write down what that care plan is. And then the money aspect of it is from a legal and financial standpoint, setting up a trust, having it be what's called a supplemental needs trust. Uh, that will spring into being upon your passing, and then just making sure it's funded well in terms of from a financial standpoint. All right. So that was the first question. Now, the second question I have submitted, and again, if you do have any questions, feel free to put it in the Q&A because this is the last one that I have. So give me just a second. Screen's open. This button. Sorry, I should have had this already going. Technology, it's great. All right, here's a question that just came in. And let me now share my screen. Sorry for the delay. I am sharing my screen again. All right. So this question just came in. How often should you update your revocable trust? And I would not just say trust, I would say your estate plan. Just because trust is a piece of the estate plan. So typically, the estate plan will have a trust, will, financial power of attorney, medical power of attorney. I'm going to give you the lawyer answer. It depends. So I don't really know. Typically, we recommend that you review it once a year. In fact, we have what we call a client care program where we sit down with our clients and review their planning because things change. And really, the two things that change, like family situation, like maybe now there's grandkids, maybe you want to disinherit one of the kids, maybe someone you named passed away, maybe your power of attorney moved out of states and you want someone local. So there's going to be changes in your world, like major life changes. That's always a time to review that estate plan. The other thing to think about, changes in law. So the laws are always changing. We are going into presidential election time right now. I don't know if you've heard, it's been in the news a little bit. But within the last year or so, there hasn't really been any big changes. Probably the biggest law change we've had that affects estate planning recently was 2020 when the Secure Act passed. And that changes how we leave retirement accounts like IRAs and 401ks to the next generation. Prior to that, we could stretch out the taxes over the lifetime of the beneficiary. Now we have to pay all the taxes within 10 years. So if your estate plan's older than 2020, I'd say that might be something to look at, especially if you have retirement accounts like greater than say 250,000. Just because in terms of how you leave things to the next generation, there might be some changes there that you would want to make. Prior to that, big law changes. 2014, Michigan passed a state recovery. So if you were to go to a nursing home, they could actually place a lien on your home unless you plan properly using something like a ladybird deed, which is like a beneficiary designation for real estate. 2012, there's a big change with regards to powers of attorney. So if you're in Michigan and you have a financial power of attorney, that needs to be updated for changes in law. 2004, there's the HIPAA authorization, so change with regards to the medical power of attorney. So if your estate plan's that old, it really needs to be updated for changes in law. And then the estate tax has always been changing. So it's been over my career, almost 20 years now. It's went up, it's went down, it's gone back up, and it's scheduled to come back down. So if you're on the higher end of net worth, estate taxes might be something that you need to update as well. And then the third thing is, especially if you have a trust, this is a big one. Making sure the trust is funded properly. So funding the trust. One of the big things we see is people created a trust. Think of the trust kind of like a suitcase. So the question's coming in. If you could provide me a little more context on that. So the third thing would be funding the trust. So making sure that all the assets that you have, all your different financial accounts, all your different real estate is pointing to the trust. So sometimes other firms would give clients like a funding letter. Okay, they create your legal trust, your estate plan, create that piggy bank, but they don't really give you exact instructions on how to get the assets into the piggy bank. So one of the things we see is a trust that maybe it was created a number of years ago, it's not funded correctly, either initially, or maybe it was funded correctly initially, but now you've accumulated some more assets. Maybe you didn't point that asset to the trust. Like, let's say you buy a cottage up north, okay, and you title it's just in your name, and you pass away. Even if you have a trust and you didn't title it to the trust, it could end up going into probate. So that's something to review as well, is make sure, and this is with our client care program, we send our clients like a questionnaire of asking them to provide all their account information. And it is a little bit redundant, but it is a process to make sure that there's not a new asset or account out there that's not pointing to the trust. Because the last thing we want to do is have a trust and something end up in probate. So we need to make sure the trust is funded. That is vitally important. All right. And then here's kind of a question. I'm not quite understanding exactly the question. Oh, that's not it. So questions coming in. It's about our high yield savings accounts. Okay. So one of the things that's going on right now, the last couple of years, maybe 2 years, is interest rates have really shot up. Where previously, if you had money in a checking savings account, you get like 0 or 1% if you're lucky. But right now we have like liquid high yield savings accounts that are around 5%, where you connect it to your checking or savings account, you can move money in and out, and you're getting a 5% rate of return on it, which is, at least in the time of my practicing, some of the highest interest rates we've ever seen. And so that's where, especially if you have money locked up in old CDs and stuff like that, before you lock it up in another CD that you're going to be locked in for 6 months or a year or 3 years or something like that, there's things that are liquid that are giving you comparable rates of return right now. And we use a couple companies. One of them is Flourish. So hopefully that was helpful. All right. Another question coming in here. Oops, hold on. Let me try to copy this. Oh, it's not. Of course. So the question is, when is better to pass an asset to beneficiaries rather than owned by a trust? So the question is, in terms of, so there's really, it's getting to state administration. So with this, when someone passes away, there's really only 4 ways assets can transfer. So one is joint ownership, which is great for a married couple, but I wouldn't recommend naming your kids joint on different assets because you're opening yourself up to all the liability of the person. Next would be beneficiary designations. So this is where, like your 401k, IRA, you can pick beneficiaries. Third would be through a trust. And there's different types of trusts. But if an asset doesn't pass through one of the first 3, then it ends up going into probate. And that's what we always want to try to avoid. So the question is, if you have a trust, is it better to pass assets through the trust or through directly to the child? So do you name the trust as a beneficiary, or do you name your children the beneficiaries? Well, at least in our office, what we would recommend is that you always name the trust. The only difference would be if it's a qualified account, you would name your spouse first and then trust. But there's no downside in naming the trust. It's not like different tax rates or anything like that. And in fact, all it does is confer or offer more benefits to the beneficiaries, depending on how the trust is set up. If you name the trust, now the kids get protection from divorces, lawsuits, creditors, the money stays in the bloodline. Versus if you're to name the kid outright, that money could go to a spouse. It could go in a direction that it wasn't supposed to. It can lead to confusion. So we 99% of the time recommend naming spouse as a primary beneficiary of any qualified accounts like 401ks, IRAs. There's a tax reason for that. And then next would be the trust. So almost always in our office, when we have a trust, we're naming the trust as the beneficiary, because that everything funnels into one spot, and that's your rule book. If you don't name the trust as beneficiary, then it could go in different directions. And there's just no advantage to it. So I wouldn't recommend that. So. All right, that is all I have this week. We will be on for next week. The following week, I'll be traveling to a continuing education events, but we will